Put briefly, the reasons given in a judgment written by all 8 justices in the majority are as follows. Section 2 of the 1972 Act provides that whenever EU institutions make new laws, those new laws become part of UK law. The 1972 Act therefore makes EU law an independent source of UK law until Parliament decides otherwise. Therefore, when the UK withdraws from the EU treaties, a source of UK law will be cut off. Further, certain rights enjoyed by UK citizens will be changed. Therefore, the government cannot trigger Article 50 without Parliament authorising that course. We reject the government's argument that Section 2 caters for the possibility of the government withdrawing from the EU treaties. There is a vital difference between changes in UK law resulting from changes in EU law, and those are authorised by Section 2, and changes in UK law resulting from withdrawal from the EU treaties. Withdrawal affects a fundamental change by cutting off the source of EU law as well as changing legal rights. The UK's constitutional arrangements require such changes to be clearly authorised by Parliament, and the 1972 Act does not do that. Indeed, it has the opposite effect. The referendum is of great political significance, but the Act of Parliament which established it did not say what should happen as a result. So any change in the law to give effect to the referendum must be made in the only way permitted by the UK Constitution, namely by an Act of Parliament. To proceed otherwise would be a breach of settled constitutional principles stretching back many centuries. The dissenting justices consider the government can trigger Article 50 without an authorising Act of Parliament. Their view is that the 1972 Act, taken with the 2008 Act, renders the domestic effect of EU law conditional on the EU treaties applying to the UK. In their view, Parliament has not imposed any limitation on the government's prerogative power to withdraw from the treaties, and if Article 50 is triggered, EU law will cease to have effect in UK law in accordance with the 1972 and 2008 Acts. On the devolution issues, the Court unanimously rules that UK ministers are not legally compelled to consult the devolved legislatures before triggering Article 50. The devolution statutes were enacted on the assumption that the UK would be a member of the EU, but they do not require it. Relations with the EU are a matter for the UK government. The Sewell Convention plays an important part in the operation of the UK Constitution, but the policing of its scope and its operation is not a matter for the courts. We thank all those who have played a part in helping us determine these important legal questions. Copies of the full judgment and of a summary version are now available on the Supreme Court website. The court is now adjourned.